The meeting of the Northampton Zoning Board of Appeals. My name is David Bloomberg. I'm the chair, and I'll introduce to my far left Bob Riddle, who's an alternate member, and the three voting members are Barry Smith to my left, myself, and Sarah Northrop. The first matter we're going to hear is the appeal of the building commissioner on alleged zoning violations of the Northampton regional landfill and seeking discontinuance of the uses of the regional landfill, the property at map ID 42-089. Notice of this hearing was published on May 29th and June 5th, 2008. Before we start, I think we'll talk a little bit about format and schedule here before I ask the appellant to present the appeal. First of all, for tonight, we have two time constraints. The first is that we lose this room at 7 o'clock to the planning board, I assume. So this board will be moving to Mr. Fiden's office in City Hall, which is a very small room. The second constraint is that at 7 o'clock we're hearing another application on another unrelated matter. So that gives us a little less than an hour and a half today to begin hearing the appeal concerning the landfill. And I think that I know there have been some discussions about scheduling, but I anticipate that what we would be able to accomplish tonight is to hear the presentation of the appellant. After that, we would normally hear from people who would like to speak in favor of or against, or who are looking for information, more information from the appellant, including members of the board. And then the property owner, and that is the city of Northampton, DPW, would have an opportunity to present a response. I'm assuming we will not have time to get that far in less than an hour and a half. So we will also need to have a discussion about the dates that we can continue the open meeting and the hearing to. And as part of that discussion, I understand there have already been some conversations about extending the deadline for the Board of Appeals to render a decision, which I think now is July 31st, in order to accommodate as best we can the schedules of the board members, counsel for both parties, and other participants in the hearing. If at any time first you have trouble hearing me or anyone else, I should add, let us know so that we can try to tweak the sound system that is here. Anyone who does speak, please address all comments to the chair, not to each other. And it's very important, especially for the stenographer who will be recording the proceedings, that everyone who speaks identify him or herself by name and address for the record. I think what I might do is ask the appellant or the representative of the appellant to come forward so that we could talk a little bit more about the scheduling issues before the actual presentation is given by the appellant.
Good evening, Mr. Bloomberg. For the record, Peter Koff, I'm representing the appellants in this matter. And I apologize, I did address apparently inappropriately to Ms. Northrop as the chair a pre-hearing memorandum based on information.
May I ask you to keep your voice up? This air conditioner back here.
I'm just going to apologize that you were not the named chair on my letter and with the pre-hearing memorandum.
No problem. So what we're looking at for dates, we typically meet on the second and fourth Thursday, normally in this room, normally at 5:30. In the summer, we usually only have one meeting a month in July and August. 2 weeks from tonight is June 26th. I guess I'll first ask the board if that will work for all of us, so that as a first target, we could plan on continuing after we complete, after 7 o'clock tonight, to June 26th. The second and fourth Thursdays are not set in stone, and even 5:30 isn't set in stone, and it's more custom. The next second Thursday is July 10th, and that does not actually, I'm out of the state that week, and I know we're going to bump into vacation schedules. So the following available, or I should say the fourth Thursday in July is July 24th. I'm just sort of putting some dates out here now. I suppose the other thing we could do is just for now set the next date one, so we know when we're coming back, and maybe turn the conversation to the issue of extending the deadline for rendering a decision, because I think we have some vacation conflicts in July. I'm looking at Attorney Shepard also.
I have a conflict on the 24th.
Of July, yeah. Which might push us into August, and I understand that the parties may be amenable by agreement to extending the deadline for the board's decision. And if so, I think we have the appropriate document to be signed for that purpose.
As far as the city's concerned, we have no problem with an extension, but as you know, the extension is between the appellant and the board.
Right.
It has to be filed with the city clerk before the 100 days runs. So if the appellant wishes to extend the time, then we agree that that's fine.
Mr. Chairman, just on that point, I have previously told Mr. Fiden, and tonight I've told the other attorneys I'm willing to do that, and I understand there's a form, I'm happy to sign that, so that so the board has enough time to make its decision, and we have a schedule that makes sense for everybody to do it efficiently.
Right, because the other item that I anticipate is that we all received your brief today, so certainly the property owner has not had an opportunity to review and respond to it. So as part of this schedule, this would give the city the opportunity to respond to the brief. And what we might do, if it makes sense to people, is begin the appellant's argument today, finish up as needed at the next session, allow the public to speak, then hear the city's position, and perhaps after that point, accept a brief from the city if the city wants to submit a brief. Does that make sense? Yes. Yeah, and then and we can talk about additional briefs after all testimony's been entered on as well.
Right, because I will want to do one at the close of the hearing. Do we want
Schedule
to?
is fine. If you want to set up a schedule right now, it's fine with us.
Well, can we agree, first of all, that 2 weeks from tonight would work to continue the hearing?
Yes.
After we finish at 7 p.m. tonight?
That's the 26th.
That is June 26th at 5:30 in this room.
How long can that hearing continue?
That one, I think it would be the only matter that we have on that night. Do we lose the room at 7 o'clock?
We can move the plan where else.
So we could have the room, and we don't have any other matters for that evening. So hopefully we can get a lot accomplished that night in terms of any time. You need to complete your presentation, time to hear from the public, and for any questions from the board, and then for the city to begin its presentation, and maybe at that point we'll make a determination about the next available date. Yes, sir.
I'm Tom Mackey. I represent the DPW, and so landowner in effect. And the only limitation on that would be submission of briefs before the 26th. Because based on our conversations with Wayne earlier, we've been outside trying to schedule all this stuff. That's a pretty tight schedule because Wayne would need it actually well before the 19th, which is a week from today. Is that
Right. The goal is you have your package. We can get around. The alternative is you all email is if they email it to you, that gives a couple more days. try to give you a hard copy.
And I assume that you want to have your brief timely submitted before the next hearing, or is that critical?
I think it would be preferential to the board to have our brief before the next hearing,
Yeah.
so that you can understand what we're going to come in with.
Yeah.
But that time frame is so, it's a little tight for me. I won't speak for Mr. Krieger, who's representing Amoresco, but I'll just volunteer that he's got a trial, so he's got a little bit of a time to produce it.
Well, that's the week I'm away. Yes, sir.
Art Krieger from Anderson and Krieger representing Amoresco. I don't have a problem with the 26th, and I don't have a problem submitting papers before then. I couldn't submit them a week before then, or 12 days before then. But if you can take an email 3 days before the 26th, or something like that, that's fine with me.
I think that's fine for us. Attorney Mackey, is that?
Sure, that works.
Okay. So then, the next hearing would be June 26th, 5:30 p.m. here. Briefs from the property owner, would it be the 23rd, 3 days before, by email, and the email is available, I'm sure, through Mr. Five's office.
There's a planning office, we can forward it around to everybody,
Right.
including the council.
Right. So in other words, you just have to email it to Wayne, to you directly, and then he can circulate it by email to all of us. Does that make work for people?
So the end of Monday the 23rd?
Yeah.
Did you want to set a time after that when you're going to deliberate?
We can try to. July 10th is not good. July 24th is not good for.
Mr. Mack, Mr. Mack and I would
Okay.
talk about time.
So that the next date I've got is, at least sticking to second and fourth Thursdays, is August 14th. We know that would work.
I think that works for me.
But that's
That will probably be the way.
That will not work for me, unfortunately.
okay. How about August 28th?
That's fine.
What about August 7th?
August is
Does August 28th work for everyone?
Yes, it works for me.
Yeah.
Okay. So that if Mr. Cox submits something today saying that it's
Right.
acceptable,
We need the agreement now. I
we
think
need
is
the
what you're
agreement
saying.
now so we can file with the city.
And you have the document. No, there's no meeting. At least not for this matter. I don't know. We might have some other agenda item.
I think we're going to try to do, leave those nights free. Any other things that come in, we're going to give to the law. So
Now we have to fill in a date. This is to extend the time period for filing a decision. So we'll need time after the 28th of July.
right. From whenever you
August.
vote, staff would like to have 10 days.
Sure.
Yeah.
Yeah, 28th of August. So we need at least 10 days after the 28th of August. And that's assuming we're heard everything. We close the public hearing and we're ready to vote. September 15th. One more hearing date.
The only date we haven't built in is my brief at the close of the testimony. So before the deliberation.
Right. We can sort of pick a date because we have a big gap. We have the month of July in between.
Well, I'm not getting their brief until, as I understand it, July 23rd.
June 23rd.
I'm sorry. I'm sorry. Okay, and then we're coming back on the 28th for,
Then we're back on June 26th.
yeah,
And then after the 26th, the next time we're back together is August 28th.
okay.
And that'll be, I assume, that'll still actually have to be open meeting. We can't close the hearing because we can't accept your brief if we close the hearing. So we would anticipate not needing any more public input. But
For that meeting or hearing, normally you would want me to have materials to you by when? In terms of August 28th. I'll get it.
the more time, the better. But to
A
be-
week before that?
Well, that would be ideal, but to be fair, we're accepting it 3 days before from the other side, so
Okay, as soon as possible, no later than August 25.
I think we need more than a week before because other attorneys going to review your brief and have a chance to supplement their brief, and staff wants to review and review it after.
Okay, so if we can push that date up for that reason.
A promise, I leave July 25th for a 2-week vacation. And then I'm away August 14th, 15th, 16th for a family.
Well, it doesn't matter to us to move into September, so if that helps.
Doesn't matter to me.
Okay. So, do we want to change that August 28th?
Do you want to have briefs due, a week before the 28th, if you'd like to do that? The 28th will be your final public hearing, where you're hopefully not taking testimony, you're just taking briefs. And then we can formally close the public hearing on the 28th and deliberate in early September.
Okay.
Yes, I'm sorry.
So the suggestion is to back up. The city's, it's DPW's brief, I guess technically is the party. DPW's brief by July 23rd. Next hearing here, I'm sorry, June 23rd. The next hearing here, June 26th at 5:30. The appellant's rebuttal brief, whatever we're going to call it, is August 21 for submission. A hearing, August 28th, where we anticipate just a hearing on the briefs and no more public testimony. But then extending the time period for filing a decision on the appeal well into September in case we need another hearing date, in case there's another round of briefs. Unless you just want closure on that.
Well, no, because presumably you're getting briefs by August 28th, but you're not going to get your deliberation. So you're going to want 1 or 2 meetings for deliberation.
Okay. We're not meeting. We're not talking about meeting on the August 28th.
Yeah.
We are. Okay.
We're going to have briefs on August 21st.
So meeting the 28th, and you're suggesting we schedule at least one more meeting in September now.
Right.
Okay.
The 28th will be your final public hearing.
Okay.
Even though testimony will be done sooner, and then September 11th, if that's what you want, would be your first deliberation. And then you can deliberate one night.
So all we're adding to the list is one more meeting on September 11th for our first deliberation.
But your meeting would still be open so that they could get briefs and you could get rebuttal briefs to.
Yeah, I think that's the idea, that we will keep the meeting open
Until
so long as anybody wants to file a brief within reason.
Right, because we won't know until we see their brief
Right.
on the 21st.
Right.
Whether or not.
Right. Yeah, Mr. Green.
I may be swimming upstream here a little bit, but it seems to me a slightly different sequence would work better. Mr. Koff's filed a brief. You'll have our briefs on the 23rd.
Right.
Everybody will have filed opening briefs.
Right.
The next briefs, it seems to me, should be after we know the hearing is closed, so that they can respond to all, they can be true post-trial briefs.
Except I thought that technically we can't accept a brief if the hearing is
You can
closed.
accept briefs, and it's like a post-trial brief in court. Trial's over.
So you're going to have to slow down a little bit.
Sorry.
We can accept briefs.
In my view, you can accept briefs as long as you're not accepting any new evidence. You can accept argument about the public hearing and all everything.
Even under the open meeting statute. I
That's
thought once we
I'd
got the list.
rather have you just leave it open and, I mean, whatever the time frame is fine, but I want you to leave the hearing open so that there's no question that you're within the
And
statute.
that you have the ability to file briefs.
Yes.
You agree with that? Yeah. You may just be looking at a third round of briefs if August 28th contains some more testimony.
Yeah. Well,
I
that's
think it makes sense.
I think we're fine with that. I think we're just saying to be safe, we'll keep the meeting open. We won't close the public hearing.
I'm not sure it makes sense then to meet on the 28th. Yeah, I guess I'd rather turn it back to Mr. Hoff and say, you want to get his brief.
Okay, so
want the city
the appellant's brief by the 21st, any rebuttal brief by the 28th from the city?
Well, that's the question for time, but my suggestion is you don't meet
We don't need to meet.
until you're
If you don't
fully
get the brief,
briefed.
we take more time because we're really sort of rushing on the first round.
It's the 26th.
of
28th of
August.
I want to join in this upstream
Yes.
kayaker protest.
Go ahead.
I think the suggestion that Mr. Krieger made makes sense.
Yeah.
Because,
Say it again then.
well, the suggestion would be that whenever they submit their first brief and then the hearing is going to go forward, at the end, after the close of all testimony and public comments, we would all at the same time submit our post-hearing memorandum on one date. I think that's what you were suggesting.
It can be one date or sequential, but my point is it should be after the hearing's closed. If the,
I just want the hearing technically to be open, that they can say
Tom,
that.
can we keep our voices
I'm
up,
sorry,
please?
I just want the hearing technically to be open so that we don't run into a problem with the statute. We have a 100-day limit, and I just want the hearing open. You can decide that you're not gonna take testimony, and that you're only gonna take briefs after a certain date, but, September 11th, when you're deliberating, I want it to be open in case you determine that you need to have more evidence.
So the question for all the parties then is the city's attorneys and Amoresco's attorneys comfortable that you'll be filing briefs the same time as the appellants, and therefore you won't be able to review their final brief?
each side may want to do a short rebuttal, it seems to me, if Peter won't have seen ours and we won't have seen his, but I think we'll all be conscious of not belaboring you with too much paper either.
I think that was a yes.
Okay, so
Thank you. Simultaneous translation.
so final briefs by all parties August 21st, and then responses to those briefs by
September 1st.
By September 1st?
And then you'll have your hearing on September 11th.
That work?
And no hearing on August 28th?
No hearing, just submitting briefs. You can
Okay,
hear-
so let me
you can
read,
hear all
let me
those
try to
other
read this
cases.
back again. So, backing up to the beginning, after today, June 23rd is when the brief will be due from DPW. June 26th, we have a hearing here at 5:30. August 21st will be the date, the deadline for so-called final briefs. September 1st will be the deadline for, I'll call them rebuttal briefs, I don't know what the term would be. And then September 11th would be the meeting where we deliberate. And now that brings me back to the date, you need 10 days after we make a decision to have time for your staff to prepare and file a decision. So could we maybe say extend the time period for filing a decision to September 30th? Does that make sense?
Fine.
And I'm going to plug that date in.
You want me to come up and sign it?
Sure, yes, please. And I guess this calls for a motion to for the board to enter into an agreement with the appellant to extend the time period for filing a decision on the appeal of the building inspector's decision relating to the landfill in this matter.
So moved.
Second.
All in favor? It's unanimous. Okay.
One more procedural detail.
Yes.
Would it be advantageous to the board to have us do all of our filings by email in order to save the production of 12 copies and packages going back and forth? I'll caution though, I think there are going to be probably some significant PDF attachments to that. It could be pretty big documents.
Well, one suggestion would be that anything like a brief that's on 8.5 by 11, we could take electronically. but we would ask for hard copy for oversized documents. Does that make sense, or if that helps?
Just for purposes of serving debt service deadlines, if we can email it rather than overnight it and all that stuff, it saves everybody.
I think that's fine, as long as we don't get into a situation where we're getting the briefs, in the text of the briefs on 8.5 by 11, but that have attachments reference that we don't get for a substantial time later. As long as we get the of course, it's in your best interest to get us the attachments simultaneously or in a timely way.
My concern is not actually the size of the plan, let's say. It might be a big engineering plan. It's more just the number of pages of PDFs, files that might be attached. I could see an exhibit.
The size of the file.
Yeah.
Okay.
Which just, I don't know how handy everybody's computers are that they're opening them up on, and sometimes you have to break them up. That's the only downside that I see.
Are we in agreement?
Well, just assume that the luminous document is done by the city and then distributed elsewhere.
Well, I think we are talking about that for. I think for oversized documents, that is our.
I think it's probably, all the attachments we should get as a paper copy. If it's a legal brief, we actually write it itself as a relatively small document. Email to you.
All right. That works for you?
I think that's it for procedural issues. Any questions from the board about the process? Okay, good. So I think that gives us about an hour to hear from the appellant.
Thank you, Mr. Chairman.
Excuse me, sir. We're trying to make a decision. I think we'll be okay to turn it on. If we get overheated, we'll turn it back on.
Okay. Not to further belabor procedural things, but just to kind of conclude that I've spoken with the attorneys for the city and for Amoresco about are both trying to come to some factual stipulations, which we can try and do in our offices in Boston, and then perhaps be able to file a document along that line with the board. So I'm hopeful that's going to happen, and therefore I'm not tonight going to be providing a lot of documents that are the basis for the factual statements in my pre-hearing memorandum, although most of those did come from a Supreme Judicial Court decision. But we hope to cooperate on the facts. The second thing we hope to pull together, I've talked to counsel about, although I'm not sure Ms. Shepard was part of this other conversation, and that is come to an agreement on what provisions of the ordinance, the zoning ordinance over the years may be relevant. Not to agree on its meaning or application necessarily, but I've got a fair amount of the history, but it may not be totally complete. I'm going to share what I have. We're going to try and meet and at least have an agreement on the ordinance background that is part of your decision.
Would it be helpful if we set a date for submitting a stipulation of facts, or is that not really necessary? You'll just work together, and if we get something, we do. If we don't, we won't.
It's totally the board's pleasure, and I'm open to a date. I think we're going to work in good faith quickly.
Yeah. I guess for now, we'll just say, from my standpoint, it would be obviously very helpful to have a stipulation as to facts, and to the extent that we can also get an agreed upon itemization of the sections of the ordinance, both present and prior, that are deemed to be relevant by agreement of the parties. Again, I guess for now we'll just say yes, that would be helpful.
Okay. Okay. Then I think the last procedural item to mention is, and I've suggested this outside as well, that there be a view by the board of the property in question and the nature of the landfill. And then I was asked, should that be part, or am I asking that to be part of a formal notice hearing, or should the board members be asked or suggested that they, if they haven't already seen the property, do it on their own? I'm open to either one, but
I guess it would, my reaction to that is we certainly can go there on our own at our convenience, unless any of the parties feel very strongly that they would like to have something more formal happen in terms of
If they have particular things they want us to look at.
yeah.
I just want to be careful that you're focusing on findings of the actual issues before you.
Yeah.
And not other.
That's a good point. This is for the benefit of everybody in the room. What is before this board in this proceeding is not the question of whether there's a detrimental environmental impact caused by the landfill. What's before this board is the question of whether the current, well, very specifically, whether the building inspector, who's the zoning enforcement officer, erred in denying the request of the appellant to find that the landfill is presently being operated in an illegal fashion because of the failure to obtain permits at an earlier date. So I think it is worth remembering that the focus of these hearings is limited to the matter that's before this board and the jurisdiction of this board. The purpose of these hearings is not to pass judgment on whether the landfill is detrimental to the environment, or even whether it should or should not be expanded. And so I guess I think that's your point, right, in response to the question about visiting the site. I guess to finish a long-winded response, why do you want us to see the site? I suppose becomes the question. And maybe we'll get to that during the course of the presentation.
well, perhaps we can just reserve that issue. There is going to be a presentation with some photographs that show the site and make the points that we feel need to be addressed, and then we can come back to that. But I do want to just clarify, while perhaps the overall detriment to the environment, as I understood the chair to suggest that is not relevant, clearly under General Law Chapter 48, Section 6, one of the issues is increased detriment to the neighborhood.
If we were being asked to make a finding, but and that may, and one of your issues may be whether that should have happened, but I don't think that's the same as saying that's what's happening here and now.
Well, we'll get into that in the argument. And just lastly, before we start the actual presentation, I was asked this afternoon late by Wayne to provide 12 copies of the pre-hearing memorandum. I have another 7 or 8 or so. I unfortunately was not in my office, and I can provide these now if you'd like, or
I was able to print enough copies for them, so it's like a copies for the public.
I think I have.
This letter, June 12th,
I have a letter of today and a memorandum.
we have it,
I think we have it.
So I'll just take it for file copies and public copies, but we're fine with them.
And then I think there's a question, Mr. Green.
Really a comment, Mr. Chairman, thank you, and I'm sorry to interrupt the preliminaries here. Your identification, yours and Mr. Cross' identification of the issue on the merits of the case was correct. There is a threshold issue of anyone standing to bring an appeal to the ZBA. As you may know, appellants to the ZBA need to show standing just as a plaintiff in court would need to. So at some point, we're going to be addressing the neighbor's standing, and that's an issue that the board must find that someone has standing in order to reach the merits, so it is a threshold issue. That may inform your decision later on about whether to take a view. I don't have any strong argument one way or the other at this point, but I wanted to make sure the record reflects the full scope of the issues before you.
Understood. And so we'll set aside for now the question of the view, and certainly everybody has reserved the rights to make whatever arguments they think are pertinent.
And on the standing issue, I think we come in with a presumption of standing, at least for some of the appellants, and rather than argue that now, I'm going to go forward with our case because we've been here too long on a lot of other things,
right.
and I'll just avoid any further arguments, procedural. Otherwise, I don't think the case needs a lot of introduction to this board. I'll get to that later. I do want to start our actual presentation by having a witness who's one of the appellants provide testimony. I don't know if witnesses before this board are sworn or not, or to.
I don't think we do that.
Okay, then I'm going to ask at this time for Mr. Fedora to come up, and he's going to provide some factual information about the property, its uses that are relevant to the issues that we are raising. And Ms. Heisinger is going to be operating some slides that will be illustrating Mr. Fedora's testimony.
Okay.
So why don't you come up and why don't you introduce yourself, where you live, and then we can just get going.
My name is Michael Fedora. I live at 238 Glendale Road, Northampton. The question is, have the lives of the people who live on Glendale Road been impacted by the expansion of the landfill, serving roughly 40 townships and day haulers? The answer to that is, of course it has. Of course they've been impacted. This first slide shows the topographical map of the Amasa site before the landfill was initiated. This is an aerial view which was taken a couple of months ago, showing what the landfill is currently. This is a zoning map, current zoning map number 42, showing the location of the landfill. This aerial shot actually shows Glendale Road and all the homes that are on Glendale Road in the close proximity to the landfill.
Excuse me just a second. If you find it appropriate, you could go up to the screen and point to things, if that would be helpful. I assume the board would find that appropriate.
That's fine.
Sir, if you could just keep your voice up for me?
Sure. May I interject a question just to Mr. Copper? Copies of these in the record or available?
A copy of these is being made available, if it hasn't already, to Wayne, and I have a copy that I can make available that's on a flash drive that I have. So I will get you maybe on a disc if that would be appropriate. I'll give you a disc when we get back to Boston.
It shows the homes that live on, the people that live on Glendale Road, the close proximity to the landfill. This would be cell 1. This is a current line landfill. This is a capped, unlined landfill. Our property is here. Hannah Brook by this green, and the wetlands and the tributary that feeds Hannah Brook. This is a topographical map showing the wetland itself, the tributary, and Hannah Brook. and that would be the landfill property, just to show you the close proximity. This is the original site map. This being the cap section right here that we saw in the photo, and here's the current section right now that's being filled in at the moment.
Could I ask Mr. Fedor a question as it goes through?
Sure.
Can we go back? Mr. Fedor, what is the original location where landfilling commenced in 1969?
Would be in this section right here,
And the one that says capped on line?
capped on line. Correct.
And do you know approximately when landfilling ceased in that section?
Roughly 1990.
Thank you.
This is a graph that shows the tonnage increase, 1990, then it just increased exponentially, which also increased the heavy truck traffic on Glendale Road, which that in itself impacted the people who live on Glendale Road. There are families there, lots of small children. They have the trucks, the noise, the fumes. There's a lot of, this shows you the tonnage increase, which shows you also the traffic increase.
Just for the record, the written record, could you call out the approximate tonnage amount for 1990 and then several of the other years?
1990 was under 10,000. 10,000? Under 10,000, and then it jumps up to just about 50,000. 2001, it was over 50,000. 2003 is just over 40,000.
Thank you.
And what's the source of that information?
The source is, and I'll provide that for the record, it's records that we obtained from the Department of Environmental Protection.
This is a map showing the 40-plus townships that actually truck their trash to the Northampton landfill. And this is a listing of those communities. This is an aerial shot of the current landfill. It shows a cell tower over in this section. There was an area right here that was a wetland. It was an active beaver swamp at the time that they wanted to expand this. They drained that because it came into the footprint of the landfill. But they're filling this in, and you can see all the homes that are close by. This is where the proposed expansion would want to be, where it shows a lot of water up that way too. Linda? This shows the elevation from our pasture. Shows the elevation of that landfill, and there's a utility pole here which is over 30 feet high. That hill is higher than any residence on Glendale Road. So any odors that come off of this landfill, everyone gets it. If the wind changes, then it hits Route 66, Glendale Road, West Farms, the entire surrounding community is extremely high.
Mr. Fedor, just going back to that picture, in 1990, did that large hill in the background of the landfill, was that in existence?
No, this is the current landfill here, where they're filling it now. They had to go to a vertical expansion, so it would probably higher. They're filling this now to bring it to the same elevation, I believe, to the...
Do you know approximately how much higher in elevation the landfill changed from 1990 to today?
I don't have the exact footage of that, but it is quite high.
Would it be more than 100 feet?
No, I don't believe it's more than 100 feet, but...
More than 50 feet?
Yes, I think so.
Okay, we'll try, Mr. Chairman, we'll try and get that figure for the record.
This is a picture of the portable candlestick flare. We see this from our kitchen window 24/7. There's an excavator here To give you a proportion in size of what that flare is, that excavator is about 20 feet high. That's a pretty big flare. We see that quite visibly from our kitchen window. The equipment is there to take and start the permanent flare. We hear the equipment from this candlestick flare all the time. We're hoping that the new flare, will be quieter than that one. And hopefully we don't see this flare.
Okay, on that particular photograph, did that structure exist in 1990?
I'm not sure when that came online, but it was quite some time ago.
Did
I'm
you
not
get
sure exactly what date that was.
Do you get more noise from this particular aspect of the landfill activity since it went to the expansion area?
Yes, because it didn't go online until after it was expanded.
Okay.
This is a picture of the Amoresco generator. You can see where the candlestick flare is in the background. The generator they draw the methane, which powers the generator, feeding the power into the grid. That generator is excessively loud. Excessively loud. It currently is only operating during working hours, which is helpful, but they're trying to take steps to quiet that down. We'll see what happens with those steps and how it works out, but that is excessively loud.
Okay, Mr. Fedora, which of all that equipment that's in the foreground, if any, was on the landfill as of 1990 when the original site was closed and the landfill then moved further to the east?
None of it.
When did that equipment go in?
This equipment came in, they started putting the foundations in last fall, and this equipment went in during the winter, went online, I think they started that February 13th, I believe.
Are you aware whether the city of Northampton DPW obtained any zoning permits or approvals to allow this equipment to go in?
No, I'm not aware of any of that.
Okay.
This is a picture of our wetland immediately down gradient of the landfill. We have tests on that from the city. It doesn't look very good.
Let's go back to, well, you describe that one and then I'll ask a couple follow-ups.
Well, I was just going to say this is just a larger portion of that same wetland, and as you can see, there's nothing green about that.
Okay. What was the condition of that wetland in 1990?
It was pretty orange, but it's getting progressively worse. We've been dealing with this for quite a long time, over 25 years, and it's progressively worse. This is a picture of Hannum Brook, right at the confluence of the wetland into Hannum Brook, which is showing the iron flocks going into and going downstream of Hannum Brook. This is a picture of some of the iron flock right at Park Hill Road. So that iron flock is moving down and it's past Park Hill Road now. And I think that concludes our...
Okay, I'd like you to stay up there and rather than at this time me making some further argument type comments about this testimony, perhaps the board would like to ask questions of Mr. Fedora at this time.
Well, I'm assuming that the DPW would be willing to stipulate that since 1990 the landfill has been expanded and that the expansion of the landfill has sort of ancillary effects, but I guess I won't try to speak for them. So I'm curious to hear how this presentation will tie into your argument about the legal issues. But I do have one question. What is iron flux?
That's that orange sludgy material that you saw in that wetland.
And is that
It
hazardous?
carries, yes, well, it carries precipitates. It allows precipitates to move. It causes them to move.
Can we ask? I can say something, but.
I'd be happy to call
Would like to
a further
address that?
appellant who could explain that in a little more detail.
Well,
I'm trying not to get too much into technical discussion.
right, and I'm trying to figure out still how this is relevant to the legal issues that are before us.
Well, the legal issues, if there aren't any,
I thought the legal issue is whether permits should have been obtained for the expansion, not whether there's, so how does
Right.
iron flux have to do with that?
I suppose, Mr. Fedora, you can be seated then. One of the legal issues is the absence of permits, but an even more significant legal issue is under the state statute, a non-conforming use cannot be changed or cannot be substantially extended unless certain findings have been made by the zoning board and certain permits have been obtained. So all of this testimony goes to the fact that there have been significant extensions and changes in the nature, in the intensity, and in the impacts of this landfill, and that it is not permitted under state law to be operated in the manner, in the intensity, and with the effects it has, because its grandfather status changed in 1975 and at various other times, and we're going to attempt, as I said earlier, to bring together the record of what those ordinance changes are. But this landfill, while lawful in 1969, as was determined in the Rose case, once the ordinances started imposing additional requirements, which are summarized in my memorandum, the landfill no longer was a conforming use originally in the Residence A district and then in the SR district. And the test is essentially how far beyond permissible limits of expansion or change in use has a landfill gone, and has it crossed the line so that it is operating unlawfully. There are many cases under General Law, Chapter 48, Section 6, which interpret changes of use. One of them, in a fairly recent decision, said that a hardware store changing into a pharmacy, that was a substantial extension or change in its use, and it was unlawful because it did not have grandfather protection to go from a hardware store to a pharmacy. Here we have something far, far more serious in terms of change of use, extension of impacts, extension of nature of use, and that's essentially why all this testimony through Mr. Fedora went in, to show the before and after. Once the regional landfill commenced being what the city was doing in 1990, the whole nature of this landfill use changed dramatically. And it's been done in violation of local law, and it's in violation of the state statute that defines the nature of changes and extensions of a non-conforming use. And we will certainly be putting together in a memorandum of legal points why this is the case, and we can cite state cases. A flavor of that is in the memorandum. I apologize that I was not able to provide that sooner than this morning. But that's the nature of the case. Up to 1990, the landfill was simply a municipal landfill for the citizens of Northampton. It then expanded in its focus for whatever reasons, and I'm not here to question the decisions made by city officials in the late 1980s that led to we're going to become a regional landfill. That decision was made, and there was some technical testimony as well as a former mayor who had serious reservations and concerns and signed one of the appropriation orders because he felt he had no choice since there was a state order saying the previous landfill, the previous dump, which had open burning, had to close down by July 1, 1969. So the city went into the landfill business, and it chose this site, and it was a City of Northampton landfill only for the City of Northampton's refuse. In 1990, that use significantly changed. There are now 40 or more communities who use the landfill. Hopefully we'll have facts that are stipulated to about that. And so our argument boils down to unlawful changes in use, extensions of use that have detrimental impacts to the neighborhood, far in excess of the prior grandfathered use, and under state law, they're unlawful, and there are various permits as well that have not been obtained, that are required to be obtained, and there's an open question whether the landfill would be eligible to be granted those permits. But since they haven't been granted, we can't argue the validity of them at this point. We can only say they haven't been obtained. And there's no excuse why the landfill is operating today not in compliance with the legal requirements of state law and the local ordinances. There was no reason for the building inspector, and that's the appeal we're on now, to have denied the request for zoning enforcement. The reasons he has given in the letter are not correct legally, and we'll be providing a further legal analysis of that by the end of the hearing. So we think this is a serious matter, and we think it's something this board needs to address both from a factual point of view and from a legal point of view. And the issues are not simple, either factually and particularly not legally, because the whole nature of non-conforming use extensions and changes isn't simple. There's a lot of litigation, however, that I'll be bringing to your attention. I'm sure counsel for the city and Amoresco will be interpreting these cases as they think they should be interpreted, and then you're going to have to make some decisions. And so that's it in a nutshell. I'm happy to have a witness, if you'd like, or an appellant, Ms. Heisinger, explain about the iron flocks, if that would be helpful. Otherwise, I'm not sure we have more testimony to present ourselves tonight, and perhaps members of the public who may want to comment could be invited to do so.
I'll first ask if any board members have any questions at this point.
Just as a clarification, there seem to be at least two very different arguments that you're getting, and I'd like to see them sort of separated out. And, the first is that from the Rose decision, I take it then that you interpret for the sole benefit of the occupants of the city of Northampton to mean that only Northampton residents can put their trash there. It would be nice to have that point expanded upon. I mean, after all, one could imagine that getting 40 or 39 other communities to help us in running the landfill would be a benefit to the occupants of the city of Northampton. So that's one issue.
Correct.
Sort of. Second issue, sort of over, is the nature of the use and whether it has been changed and expanded.
If you could, I'd very much like to see you address the question of change and the question of expansion separately, because it seems that, going back to your example of the hardware store and the pharmacy store, that's clearly a different use. Here, it was accepting garbage before, it's accepting garbage now. Seems to be the same use, but I agree that there might be some reasonable concern as to that's being expanded. So I guess what I'm suggesting is that in the brief, I would like to see that addressed perhaps more even than the change of use, which doesn't really seem to me now to be a problem.
Right. And if I could add specifically, if I'm curious about the focus on the presumed expansion of the use when one is, as Barry says, it's the same use, except maybe for the methane and the production of electricity, setting that aside for a minute. And it's the same use on the same parcel that was taken by the city in 1969. Within that parcel, they capped the first unlined section or cell, and then they opened new cells. But I'm curious about this idea that when the entire, I think, was it 50 acres, the entire 50-acre parcel was taken by the city to use as a dump. The fact that one cell filled and had to be capped and a new line cell had to be opened, isn't that arguably a continuation of the same use rather than an expansion of use, because it's within the same site? And I'm not expecting an answer now, but it's a question, an obvious question.
Right. Well, I think both members of the board are asking pertinent questions that go right to the heart of what this issue is about, and you're going to have to make a decision. And I certainly intend to address those in more detail in the briefs, and it's going to be something where the facts are going to then be applied in terms of change in use for different uses in the sequence of how the ordinance changed. And until one knows how the ordinance has evolved at each point in time and what the use was at that point, it's going to be, you know, with that, I think you'll have an easier time understanding the question. I understand Mr. Smith's point about separating the two arguments. We'll certainly be addressing those in a way that I think the board can understand.
Right, and then in terms of the production of energy there, it's what I'm curious to hear about is the question of whether that constitutes an ancillary use that might under certain circumstances be permissible, or a primary use, or any other relevant interpretation. But
we're going to have to brief that on both sides. I'm sure Mr. Krieger will be addressing that point in particular. I think there's an issue as well. I mean, as part of that whole question is it a private utility or not? Is it a power plant or not? There aren't definitions of those in the ordinance. In the first instance, this board is going to have to interpret what those uses mean under the zoning ordinance.
Also addressing the power plant issue, we have a flare that's being used to generate electricity. They'll probably want to address how the operation of this is somehow not integral with the operation of a landfill, specifically mitigating effects of methane leaving the site.
Yes. Thank you.
so we have 20 minutes here.
So
Yeah.
should we defer on the flocks, and I can do a 1 or 2 or 3 sentence statement in my...
I'd like to know if that residue is draining from the capped, unlined section of the landfill, or whether it's coming from the newer lined sections of the landfill.
Right.
I mean, it could be that has been moving since 1990 and that
Well,
it's moving essentially because
There's
It wasn't lined originally.
There's an assumption here in the testimony that that is a direct result of some phase of the landfill, which would have to be proven through an environmental study, which may or may not have been done already. That stream, that wetland, is at the furthest end of the site from the original unlined landfill. There may have been an effect, and there may continue to be an effect from the unlined landfill on that stream or elsewhere. But since then, lined and capped landfill phases are highly unlikely to be affecting that. So is this a residual effect from the old landfill? Has this been looked at? In general, my understanding of iron blocks is that there's some iron available in the water, and there's bacteria that likes that, and it does very well. And what you end up seeing is what's left, like a lot of dead, little dead, what do you call them?
Educated man.
Little microscopic organisms. They build up like sludge in a well, in a drinking water well that has a lot of iron or manganese in it. So whether or not that's a pre-existing condition, I assume there's been some fundamental information on that may be very pertinent to the neighbors and to the operational landfill, but is it pertinent to our zoning enforcement? We'll find out.
But in response, yes, there has been some information developed by the city and its consultants. I think we take exception to some of the conclusions. I think there's contrary opinion about the source of that flux, and to the extent to which that's going to become part of this in detail or another proceeding. The board is probably aware there may be other ancillary litigation involving these questions. What the right forum is to get into that, it's something perhaps we as the various parties to this larger dispute can figure out and do in a way that doesn't saddle this board with having to have expert testimony on each side of the origin of the flux. Because I think that may be getting us far afield, and it's better done in one of these other forums.
That's a matter for DEP.
Well,
or other.
And others. So with that, I'm happy to have the board entertain other people if they want to provide any testimony.
I guess we have 15 minutes in this room, so I suppose we could start if there are members of the public who would like to speak. Yes, Mr. Mack.
Thank you, Mr. Chairman. Because we only heard this for the first time tonight, we got Mr. Koff's papers today for the first time.
Mr. Matt, I'm sorry. Can you
Slow
come up
down.
here? No, just come up here too so I can hear you better.
Yeah.
It's kinda...
I'm just going to ask for the record that Mr. Koff make available Mr. Fedora and the slideshow at the next hearing in case we have questions.
Yeah, I was thinking about that. Even though this isn't a trial court, it seems fair and reasonable for opposing counsel to have the opportunity to ask questions of Mr. Fedora.
That's fine, and I assume it'll be reciprocal as we go forward.
Yeah, that seems reasonable.
Thank you. We're not prepared to do that tonight.
Understood. I guess that means I should ask Mr. Fedora if you can be available at the next hearing, or we're planning to be at the next hearing.
Yes.
Okay, thank you. Appreciate that. Anyone from the public who would like to address the board in favor of the appellant's position? And again, if you could, when you come up, please give us your name and address for the record.
Hi, my name is Lillian Fedora, and I live at 238 Glendale Road. I want to talk about a lot of different problems over the years, and one of them, and I've lived there since 1977. So we've had landfill odors probably for not exaggerating, at least 20 years. It's been a recurrent problem. In 2003, residents living near the landfill became ill after exposure to landfill gases containing chemical contaminants. They developed respiratory symptoms, burning eyes, skin rashes. A baby developed a rash after exposure that covered its entire body. Parents wouldn't let their children go outside because the smell was so bad. That was the same with our children as they were growing up. It was terrible. Residents said that it smelled like a toilet that had been flushed in their backyards. If you did not live out there, you have no idea how bad it's been. I attended one of the meetings, and there is a videotape of residents describing the terrible odors and the effects on their health, which I can make a copy for you. Terrible odors continue to be a problem from the regional landfill. In 2007 and 2008, residents have had to live with exposure to landfill gas odors and the chemical contaminants that come with it. At an odor meeting several months ago, a member of the Northampton Board of Health, Dr. Flightman, spoke publicly about the terrible odors he experienced when he went to the landfill. The truck traffic has just been unbelievable. It started off as a Northampton landfill. It was just Northampton residents. The trucks are just significant. Not only the 44 cities and towns that bring their trash there now, but from the large trucks, including the 18-wheelers, that bring in contaminated soils to cover the garbage. The larger the landfill has become, the more material is needed for cover. This has been trucked in from elsewhere in Massachusetts, including Boston, and from other states, including New York and Connecticut. In addition, other cities and towns, not on the list of the 44, can bring their waste, including construction and demolition debris, to the regional landfill by getting a day pass. Glendale Road is a residential street without sidewalks. Children live on that street. There is a daycare center at the end of the street. It's a tight squeeze to pass these large trucks, and many of them end up going on residents' lawns. I've driven on Glendale Road, I live on Glendale Road, and see trucks lining up to get in the landfill, obstructing the view of cars. There is a serious issue of public safety because of the amount and size of truck traffic on this residential street in Northampton. Unfortunately, the regional landfill has functioned autonomously. This has resulted in serious, detrimental impacts on the residents. I think the reasons for the permit process we have in local government is to have the granting authority, whether it be the ZBA, the planning board, or the city council, hear about the impacts of a project on residents, on neighborhoods, and on the environment, and then weigh whether it should go forward or not. It provides checks and balances in the process, and it gives Northampton residents a voice in what is happening to them. Thank you.
Thank you. Mr. Rick?
Mr. Chairman, I just wanted to make ask a question of Ms. Fedora, and that is, are you an appellant?
Yeah, actually, that would be helpful. Anyone who speaks, just again, so the record is clear, if you could identify if you are one of the, is it 45 or 42? 42 appellants.
Mrs. Fedora is according to the...
Yes, yeah, we confirmed she is. But yes, sir.
Yes. My name is Craig Odgers, 97 Glendale Road. I have a couple of questions. One of them is that you were talking about permits for the landfill to expand it, and then past permits that weren't obtained?
That's part of the appellant's
right. That's part of the process?
Well, the appellant's argument, I think, is in part that there were
T's
permits that should have been obtained and were not obtained.
Okay, so.
And Mr. Odgers, you're one of the appellants. You're one of the appellants, I think.
Oh, okay. So the T's weren't crossed and the I's weren't dotted for the permits, basically?
That's a
the gist
question.
of it.
Well, that's one of the questions before us.
Because all I know is that as a homeowner, a property owner, I know that if I want to expand, say, my septic system, I have to go out and get a permit for that. And the question is, why has the town of Florence or Northampton not gotten the proper permits to do the work that they were supposed to do? And they should be held accountable, the town or powers that be or whomever, for not getting the proper permits. And I think the environmental part has something to do with that. If you don't get the permits or the right zoning or everything else, then all the other things go to heck in a handbasket, you know what I'm saying. And if we're serving, what, 40 communities, you said? Something like that? Is there a lawyer? No. Oh, okay. If that be the case, if we didn't have to serve all 40 of them and we just kept it local, would we have to get the future permits for the landfill just for the people here in Florence?
Yeah, I think you're asking questions that are part of why we're here.
Oh, okay.
Yeah, are you asking us?
Well, I'm asking it, but at the same time,
Yeah.
The lawyer's the one making that argument.
Yeah.
yeah, I just believe that if I have to go out and get permits to do something, part of the reason why you have people come in to give you a permit or do whatever is to make sure things are done correctly. Am I correct?
Well, we're here to listen. So.
Oh, okay. All right. Well, that's basically it. I don't know if I can say
Okay,
anything. Do you want to say something? Okay.
Sure.
Hi, I'm Mary Odgers, and I live at 97 Glendale, and I guess I'm one of the appellant people. All right, my opinion on listening to all this is like the big issue of it's a change in use. And your argument was a hardware to a pharmacy is a change in use, so you have to get that. But a garbage expanding to more garbage or taking in more garbage is just still taking in garbage. So I guess my argument, though, is that the idea that why it would be a change in use is that because they have now taken in all these regional communities, it has actually changed what's been happening to the landfill. You are still taking in garbage, but now there's talk of expanding the landfill into a larger area. Why? If we had not changed what we were doing to the landfill and taking in these communities, would we have to expand it even further? Because we would probably, how long would the life of the landfill be if we were not taking in all this refuse from everyone else? So that's kind of what I wanted to just make a point as why I think it's a change in use. Okay?
Thank you.
Thank you.
Yes, sir.
I'm Bob Aronson. I'm not an appellate or a litigant or anything, and I live about 1.2 miles north of the landfill. And I can tell you this morning I went and had coffee, walked my dog down, and went to Jim's Variety, which is at the corner of Ryan Road and West Farms Road. And in the space of about 10 minutes, 10 heavy vehicles passed me. And someone was beside me trying to have a conversation and couldn't do it because of exhaust noise from large trucks. Luckily, I was up sun, and when these vehicles go by, and I know they're all inspected, and that's not anyone's authority to inspect motor vehicles in the city or anything, but they do an opacity test on diesel engines. They're supposed to not make smoke. And you could, plain as day, see what looked like a defective engine. And then it drifts up and you get to breathe the stuff in. So there is an impact, and the nature of the change is in the frequency and scale. There's not a fundamental change in the use, but just as you're not going to allow a 60-foot skyscraper downtown for a hotel. You know, it's just scale. And it's like importing cars into the United States versus building them here. So that's a fundamental change in the nature of that business. It's no longer an organic or local business. It's importing and exporting and taking in other products from elsewhere that we then don't have control over. And there's regulation and authorities that look and vet all the things that come in, and they do their inspection process, and we have all kinds of established law and a body of law that's supposed to monitor and safeguard the environment. And that's not your issue. Those are there for a reason, and you're here for a reason too, and that's about the zoning. The zoning is, I don't know the tenets of zoning, but my guess is it's supposed to protect residents from this kind of changes and mission creep. I lived next door to a greenhouse when I grew up, and it got bigger and bigger and bigger, and it affected people to a certain extent, and they allowed it. And it wasn't noisome. It wasn't a noisome trade, but there was definitely traffic because it was a popular place to go. So it's a side effect kind of. It's not one of the direct or malignant things that we think about when we think about a dump, but the frequency of automobile traffic, heavy truck traffic, and also it has an effect on infrastructure. And I know it's not your authority to maintain the infrastructure or the budget or anything else, but roads they're having a burden placed on them that's undue as a result of this increased frequency of heavy trucking. And the roads are falling apart. There's no sidewalks for kids. There's school buses and operating at times when the dump is open. So you have more kids on roads and close proximity with school buses and heavy vehicles and a lack of enforcement for speeding that's unbelievable. It takes me 6 months when I request the police department to do a radar patrol on my road. And I'm in almost an S-curve, and they come whipping around there at 35 miles an hour, an 18-wheeler. And then to add to that, the trucks from Willard, and they're gravel crushing. So you've got more and more trucks all the time. And it's having an effect. It's like the straw that broke the camel's back. So maybe you should take that into consideration. You know, it's a factual thing. It's not a procedural thing, but I think that's one of the tenets of zoning is to keep these kind of things away from residents. And that's why we have zoning. So that's all I have to say.
Thank you. We have 2 minutes more if there's somebody who wants to speak briefly. Yes, I think we have this lady here. No, that's you. I'm pointing to you.
Linda Heisler, 981 Park Hill Road. Since I've moved to unfortunately moved to the house where I'm living in, we've experienced horrible landfill odors caused by the gas emissions. And the reaction of the town was as if it was something new. But I did a DEP file review in Springfield, and much to my surprise, there were files of documents from when the landfill became a regional landfill. Not when it was a local Northampton landfill, but when it became a regional landfill. There have been odor issues and problems ever since then, dating back to the 90s to 2000, as Mrs. Fedora cited. It was shocking to me to see that in the DEP file. There's been a tremendous impact. There's been a change in use when you go from a small Northampton landfill, obviously, to a large regional landfill. It's an industrial landfill now. It's an industrial, regional, you can't argue that it hasn't changed tremendously. And the fact that there are so many problems, it's beyond the pale that it didn't go before the zoning board. And the zoning board, there weren't checks and balances to protect the residents, to protect the environment, to protect the children, to protect the city from any liabilities. It should have been before the zoning board from the onset. As soon as they wanted to change it, any changes, the fact that they put the Amoresco generator, they could have buried it in the landfill, they put it abutting residents' property. They put a cell tower there. They put everything there. Soon there'll be a cemetery there. Everything that, any little change, just like anything else in town, any little change in town goes before the zoning board. It's beyond the pale that it didn't go before the zoning board. Thank you.
Thank you. So I think that we will continue. Do we need a motion to do that? Or? Yeah, a motion to continue the hearing until June 26th at 5:30 p.m. in this room with briefs to be submitted by DPW by June 23rd electronically.
Second?
All in favor? And this meeting is still open, and we are moving to Wayne's office in City Hall. Is there anyone here for the next matter? Where would they be over there? Okay, so they may be over there. Thank you very much.